Welcome to the Dickinson College Expert Show. I'm Craig Lane. Thanks so much for joining us. Today we're joined virtually by Associate Professor of English and Film Studies, Greg Steirer. Greg, thanks so much for being with us.
Thanks for having me.
We're here to talk about your new book. It's called Legal Stories, Narrative-Based Property Development in the Modern Copyright Era. First, congratulations on the new book. Second, tell us about this. This is a look at legal stories, meaning not just stories about the law, but the way the law intersects with popular storytelling, meaning you looked at comic books and films and novels and that sort of thing. Why choose this topic and why seek it out?
Well, I have always been a big fan of comic books and intricate universes and fantasy books and movies. So I became just interested in wondering where they came from and how they worked legally. And I knew nothing about the law 10 years ago when I started this. But in exploring and asking questions about what glued these things together as property, I kept realizing that I needed to understand the law to answer these questions, and found that, oddly, the way we talk about the law today didn't really explain how things like Lord of the Rings or the Marvel Universe or Conan the Barbarian or all of these properties or Mickey Mouse, they didn't seem to apply to them. So I just kept going back and back and digging out old legal cases and had a lot of fun doing that.
It sounds like your idea of fun is different than a lot of other people's. I could see reading comic books, watching movies, that kind of thing, but then digging into the law. Although you focused really in a specific era from 1909 to 1978. Why was that critical, and how does that affect what copyright law is maybe today, dealing with some of these properties you mentioned, Mickey Mouse and Conan the Barbarian, et cetera, et cetera?
Well, the original way I'd conceived the book was that it would just cover all of American copyright. So I imagined chapters that would go up till roughly the present day and deal with video game properties and others. But the more I researched, the more I realized there was a pretty strong break in how the law worked in 1978. We passed a new copyright statute, the United States did in 1976. And before that, the last act was 1909. There were a couple of little amendments that extended the length of time. But so we had this period of copyright law that went from 1909 to 1976 that was pretty stable, and it changed radically after the 1976 Act was implemented, which occurred in 1978.
Right.
So I found that it was actually impossible to talk about the present day and, let's say, the Marvel Comics world of the 70s in the same book using the same kind of understanding of the law because the law was so different. So there was so much less written about this earlier period. So that seemed to be the place to go. It also was the origin point for a lot of the universes and stories that make the most money today and that we're all excited about. Superman, Lord of the Rings, Wizard of Oz, all of these predate 1978. Star Wars just gets in a little bit beforehand.
Just by a year, yeah. In 1977, yeah. But it does, and think about how massively expansive that is in an era of streaming TV, for example, that would not have existed in the 70s when this copyright law was passed.
So though the book is on this older period of history, part of the argument is that, well, to really understand where we are today, we kind of have to understand, well, what did these things grow out of that we're with today? It's actually pretty hard to launch new things, with the exception of video games. Most of the properties that are the most widely known are older.
So you use the term modern copyright era to talk about that time period that we just talked about from 1909 through 1978, but you also use the term narrative-based property to discuss these really big, overarching multi-author, multi-text, multimedia properties. And so you mentioned that we didn't think of these things like today. It's so common for us to think of things as this exists in a cinematic universe, or Star Wars has an expanded universe. There's the Marvel Cinematic Universe, of course, which is, all the various Marvel movies. It's been such a box office juggernaut. But this idea of having these multiple media that existed in the same franchise actually predates what our current contemporary perception of that is. Is that something that when you were looking at it, did it surprise you that this had really been done before, but maybe not monetized in the same way as it is now?
I don't think that surprised me because I was familiar with Wizard of Oz, which had been books. It had begun as like a Broadway stage show. Then there were movies, comics, and even Superman. There were radio shows, cartoons, toys, and that was in the 30s and 40s. But what did surprise me, or what I found confusing, which prompted me to do this book, was that the law didn't seem to understand how to talk about what these things were. So I call it narrative-based property because there was something property-like about a character. And yet, especially in this time period, when we talked about copyright law, we weren't talking about characters. You were talking about like a book's manuscript or the actual movie itself, not a part of that movie that you might lift off and turn into something else. So they really, the law and writers themselves and creators had a hard time thinking about that and talking about it, even though they were sometimes making products like the Wizard of Oz or Superman that sort of looked like they were doing it.
And so much of the copyright law, too, at the time was based on what we would call common law, right? Cases that moved their way through the system and set precedents along the way. And one of the chapters that I found interesting is dealing with this quirk of the common law system, where it seemingly grants greater copyright protection to cartoon characters, and specifically to the one case you looked at was Superman. Can you talk a little bit about that? Why cartoon characters somehow were granted more copyright protection than characters from other forms of media?
Yeah, that's probably the densest legal chapter in the book, which otherwise I hope is very accessible. The short, simple answer for that is that comic characters and cartoon characters presented a special kind of problem to the way people thought about copyright. Because when you had a book or a movie, judges and everyday people immediately thought of the book or the movie as the text. But then when you have a comic book, because of the origins in newspapers where comics started off as a single panel, it wasn't clear whether a comic book was a collection of single images. So let's say a Superman comic then might be comprised of 150 separate texts, which together make the comic. Or was it a singular text? And the law had a really hard time understanding that. The longer answer is that another quirk of this period, maybe not longer answer, more complicated answer, is that today trademark law is really used to protect things like Spider-Man, Star Wars, Star Trek. It's the stronger tool in media companies' arsenal. But back in this period, it was not used at all. It didn't, judges and lawyers didn't think it was appropriate to use for fictional worlds or characters. So that chapter argues that basically what happened with the comic book characters and cartoon characters is that judges began playing with what today we now call trademark law, but we're calling it copyright law back then.
Let's look forward a little bit. So much has been made of the Disney animated short Steamboat Willie from 1928 moving into the public domain. Do you think that's an accessible way that then we can talk about, oh, here's the history of copyright and to your point, maybe trademark? Does it make a difference that Steamboat Willie is in the public domain now?
Yeah, I think that's a really good example. In, let's say, even the 50s, the fact that Steamboat Willie was copyrighted really just meant that that text was copyrighted. And once that was envisioned to be in the public domain, then Mickey Mouse as a character would have been seen as kind of free reign. People could use him for what they want. But today, because trademark law has sort of moved in, and Mickey Mouse is now a trademark of the Walt Disney Company, that Mickey Mouse character is protected indefinitely. Trademark does not need to run out. So even though Steamboat Willie, that specific cartoon in which Mickey Mouse first appeared, is now available to us and free, the character, you could still be sued for using them. Now, this hasn't happened yet, so it's unclear what a court would decide, and there are some really complicated legal issues there. But most of the lawyers that I talked to suggested that what we're going to see is that if someone wanted to make, let's say, their own cartoon that was loosely based upon Steamboat Willie, a court would say that's fair game. But if you wanted to sell T-shirts that had pictures of that Mickey Mouse, or use him for your radio show as a logo or something, the court would say no. On top of that, the actual Mickey Mouse you're entitled to use, confusingly, it has to look like that Mickey Mouse, arguably. If he looks like a later Mickey Mouse, you are still violating copyright law because those later works are still copyrighted. As a side note, the cover to this book was made by a Dickinson student, and it features a number of she drew characters that I talk about in the cases. And this issue was raised in that because some of them are in the public domain, or she wouldn't have been able to draw them. But some of them are still copyrighted, the latter versions of them. So she had to make sure, we had to very carefully make sure that the versions she drew resembled the versions that were in the public domain and not later versions. And that same dynamic would apply to anyone wanting to do something with Mickey Mouse today.
The cover art is fantastic. And if you take a look at the book, it is pretty fascinating. You've included so many different, I guess we'd call them franchises now, in your writing here. What are the next steps for you? Does this inspire you to go any further or to a new place with additional legal stories?
That's a good question. The coda to the book, which is really short, talks about where we are today and how different this period we're in right now, in which questions of fair use really predominate. And that's thanks to the rise of the internet and all of the changes it made, as well as some really thorny questions about how trademark law will work. And so I could imagine a book that tackles these sort of is part two after 1978. On the other hand, I'm not sure that's as exciting to me. One of the fun things about this book was it required me to go into archives and dig into pretty much like lost material. So for the chapter on the Maltese Falcon and Sam Spade, I was able to go to the Warner Brothers archives and actually look at the legal team's actual legal files, which was really exciting and interesting, and sort of piece together the story that way. That wouldn't really be possible dealing with like a lawsuit over Spider-Man from 5 years ago or something like that. So it'd be a very different kind of project. And I don't think it would be quite as fun, even though it might still produce kind of new knowledge.
All right. Professor Greg Steirer, our resident comic and cinematic universe expert, Associate Professor of English and Film Studies. Thanks so much for talking with us. We really appreciate your time.
Thank you.
The book is called Legal Stories, Narrative-Based Property Development in the Modern Copyright Era. Thanks so much for watching the Dickinson College Expert Show. I'm Craig Lane, and we'll see you next time.